Welcome. My name is Christine Lamberson. I'm the Director of the History Office at the Federal Judicial Center. This is the third session in our series, Federal Trials and Great Debates in U.S. History, Judicial Independence. In this session, I'll be speaking with two federal judges about judicial independence historically and in the present. If you have not yet watched them, the first and second sessions in this series discuss the history of judicial independence in the federal courts, including zooming in on a few specific cases. Before I introduce our guests, I want to thank my colleagues at the FJC, especially Christopher Murray and all of the information technology staff for making this program possible. I also want to thank our partners at the ABA Division for Public Education, especially Kathy Hawk. For this session, we have two federal judges joining us. Judge Ann Donnelly is a United States District Judge for the Eastern District of New York, where she has served since 2015. Judge Jeffery Sutton is Chief Judge of the United States Court of Appeals for the Sixth Circuit, a position he assumed earlier this year. He has been serving on the United States Court of Appeals for the Sixth Circuit since 2003. Welcome. Thank you both for joining me.
Thank you.
Thank you.
I would like to start by asking you each to introduce yourself a bit more. Could you tell us about your career leading up to and on the bench, and why you wanted to become a federal judge? Let's start with you, Judge Sutton.
Yes, thanks, Christine. It's great to be with you, and Judge Donnelly, it's great to be with you. Let's see. I grew up on the East Coast and was out of college. I was a teacher for a while. I was a seventh grade geography teacher, high school history teacher, soccer and baseball coach, and really liked that job. But when you're young, you're impatient, and thought I would go to law school. I would not say I started out in law thinking I would be a judge. I think that would have seemed pretty presumptuous. But I was quite fortunate out of law school to get some really wonderful clerkships. And I think for most people that clerk and enjoy that experience, it's hard not to think, boy, in a dream world, wouldn't it be great to be a judge? So after clerking, I came back to Ohio, went to Ohio State Law School, and I worked at a firm for a little while. And then a very big break for me was becoming the Ohio Solicitor General for Betty Montgomery. She was the Ohio AG at the time, and that gave me a chance to get into court, which I really enjoyed. I really enjoyed appellate arguments and had a chance to argue in my current court, Sixth Circuit, the Ohio Supreme Court, and some in the U.S. Supreme Court. And that just was a really fun experience for me and probably increased my affection for the courts because I was in front of them so often. After that, I went back to Jones Day for about 5 years and then was fortunate enough to get nominated by President George W. Bush and eventually confirmed to this seat, and have really liked it. But no, I wouldn't say I started out in law thinking I would be a judge. I think that came quite a bit later.
Well, I don't think I started out thinking I would be a judge either. When I also went to Ohio State University after graduating from the University of Michigan, which I think going to both of those places probably made me see both sides of an argument. But I left Ohio State and became an assistant district attorney in the Manhattan DA's office, where I stayed for 25 years. I did appellate work for the first 6 or so years, and then I was senior trial counsel for most of my time, and I was a chief of the Family Violence Bureau at the end of my career there. From there, I was appointed by New York's governor to our trial level court. It's a court of claims, but I was assigned to sit in our trial level court, which we call the Supreme Court in New York. I sat on criminal term in the Bronx and in Manhattan and for a little bit in Brooklyn for about 6.5 years. And then President Obama nominated me to the district court, and I joined the court in 2015. And since I've been here, we do basically everything. And so I'm extremely lucky to have this position. It every day brings a new challenge, so I'm glad to be here.
On that note, could each of you talk a little bit about one or two aspects of being on the bench that you find particularly challenging or rewarding? And as you are answering this question, I want to highlight to our audience the fact that the two of you are representing two different parts of the judiciary. One of you is representing a district court, and the other, the courts of appeals.
So I'm in the district court, and a district judge sees basically every kind of case you can see, criminal, civil, and within the civil realm there are just countless variations of cases. We have an extremely busy court, like I think most district courts. We are understaffed and overburdened, I guess, but we try our hardest to keep things moving. So if we get in front of judges like Judge Sutton, they don't reverse us, but it happens. As far as the challenges, I think most district judges will tell you that the hardest thing that we do is sentencing. When you have to determine what an appropriate sentence is for someone who's been convicted of a crime. It's very, very draining experience because you're dealing with human beings that have families, and no matter what the offense that the person has committed, there are just so many human, such a human toll that is taken in sentencing. So that is a very challenging aspect of being a district judge, and I think almost all of my colleagues would agree with me about that. The great part about being a district judge, and I think Judge Sutton would probably agree with me about this in terms of being an appellate judge, is just the variety of work that you do. To me, every case is interesting, and I try to remember that even if the case doesn't seem very important, it's important to someone. And so I feel that I am learning something new every day. I'm confronting something that I haven't dealt with before, whether it's an area of law or the type of case. And so it keeps you thinking all of the time.
Yeah, so on the Court of Appeals, I mean, we're kind of the middle management situation. So it's true, review trial judges like Judge Donnelly, but of course we're reviewed by the U.S. Supreme Court. So we kind of see it all directions. A big part of our job, at least the way I see it, is often just figuring out who decides. Is this a call for the jury? Is this a call for the trial judge, say, in sentencing? Is this a call for the appellate courts because it's an issue of law? And quite often we realize at the Court of Appeals it's really a call for the U.S. Supreme Court because maybe the courts of appeals are conflicted and you have to have one decision ultimately in the federal system. So sometimes, we'll give our opinion, but we know it's just a way station until the U.S. Supreme Court finally decides it. One feature I think for both of our jobs, it's true, there's something new every day, and I really enjoy that. We do a lot of writing. I probably write 1 to 2 10 pages on average a week. Someone told me that in high school I'd be doing that. I would have said, get me a gun. That is not a career I'm going to be doing. Oddly enough, I've come to really enjoy that. So if on a Sunday night I know the first thing I'm going to do Monday morning is work on an opinion, I now have come to really enjoy that part of the job. The only thing that is difficult about that feature of the job is, I guess this is a really great thing about the judiciary. We don't just exercise power. We don't just say vote. We're supposed to explain why we did what we did, really at all 3 levels. At some point, maybe a jury verdict just has an up or down, but eventually a judge or judges have to say why that's fair and reasonable and consistent with a precedent or a statute or the Constitution. And that's really exciting to me to write that out, explain it, but it's also the hard part of the job because it seems to me this is my 19th year, and it seems, I don't know if Judge Donnelly would agree with me on this, but it seems like I've just always got something hanging over my head that I'm just not sure I've got right. I'm just like, I can see this side, I can see that side, and sometimes it doesn't make me very good company. I suppose it's really rewarding when you feel like you've sorted it out. So that's I guess I'd call that the pro-con side of it. I want to add something about sentencing because I want to echo something Judge Donnelly said and then mention a point about the Court of Appeals perspective. So Court of Appeals judges are allowed to do something which is called sit by designation. So I could sit as a trial judge. And I've done that, maybe 5 or 6 times. And I did a jury trial, civil, criminal jury trial. But the hardest thing I did was sentence. I think I've sentenced about 6 people. That is an astonishing thing to do. There's a lot of guidelines, regulation about sentencing, but fundamentally, at the end of the day, the trial judge has a very big say as to how long someone is going to stay in jail. So they've already been convicted. This wouldn't happen but for a conviction. And now the question is it a short, medium, or a longer sentence? And the reason the trial judge, I think it's just a lot harder than it is for us when we get these on appeal, is on appeal, there's no the individual may be there, but they're not speaking. Their family's not there. In the sentencing hearing, you're hearing from the family, the siblings, what's the effect of the sentence? Will they lose their house or something? And yet, on the other hand, judges have to account for the fact that, a law was broken and there's deterrence, there's all kinds of considerations. And I have a lot of respect for trial judges having to do that day in, day out, because the times I did it, it stayed with me for quite a while. And when I get these appeals, I try to get myself back in that state of mind, but usually it leads me to be quite deferential to the trial judges because I know what it was like to go through it. I assume no one would lightly impose a long or, for that matter, short sentence. So that's a who decides situation where I'm usually going to defer quite a bit to the trial judge, but it's possible there could be some interpretive issues about maybe the meaning of the sentencing statute or a sentencing guideline, in which case, the panel's probably going to look at that in a more fresh way. But I do want to echo the point that the whole system, it's probably half our work is criminal. The whole system, about half of it is, the question of whether someone's liberty is taken away for a while. And that's a very big issue in a free society.
Thank you both. Those are really important points, and they give us a sense of the work, especially the difficult work that you do. With that backdrop, I would like to turn to our topic at hand. Could you both talk about the idea of judicial independence? What does it mean? Why is it important to you when you're making your decisions on the bench? Or perhaps to speak more broadly, why is it important to the judiciary at large? Let's start with Judge Sutton.
Sure. Well, there's quite a bit to the phrase judicial independence, and we could probably go on for quite a while on it. It's so important. So what are some things it means to me? Well, some of it, you start with the Constitution. You have separate articles in the federal Constitution. Article 3 is, of course, the judicial branch, and that says something about independence, right? They didn't roll judges into the executive branch or the legislature, and it may seem odd to hear this, but before 1789, the U.S. Constitution was ratified. That actually was how it was done. It was quite often that you would have judges in another branch, or sometimes have a person acting as both a judge and a legislator, or a judge and an executive branch official. And that is very much not the American system, whether at the federal or the state side. And so that's a big start. That means when we're looking at the meaning of the Constitution, we might consider what a governor or president or a legislature thought, but fundamentally, after Marbury versus Madison, that's a call for the federal courts. And there could be a constitutional amendment, a statute could be amended after a decision by the federal courts, but that is for us to decide. So having decided that we respect their views, like we'll listen to why they did what they did, but also taking the view that it's our call at the end of the day. I think judicial independence means that you have to try to, I guess Justice Breyer said this recently in a speech that, we federal judges are not Democratic nominees or Republican nominees, Obama judges, Bush judges. Frankly, that would ruin the job if you ask me. I mean, if I wanted to be working with my political party, I would have stayed and gone to a legislative branch or run for one of these political offices. So we all decided that was not what we wanted to do. We cared about judging. For me, independence in judging is something that means a lot to me based on my years as a lawyer. So whether I was in private practice, whether I was doing pro bono work for criminal defendants, or whether I represented the state of Ohio, as a lawyer, I knew when I was getting an independent court. And, you know, every now and then you worried whether someone had some predispositions which were tough for the lawyer to overcome. And that was not as fun an experience. It's a lot more enjoyable to be arguing in front of a court where you really have the sense we're all trying to do the same thing. What does the law mean? What does that precedent mean? And how does it apply here? And so as a practitioner, I knew it when I saw it. You know, I'm really happy to say when I was arguing in front of the U.S. Supreme Court, including cases like City of Bernie, you know, I really felt like I was in front of a court that no one's perfect. They're human beings, but I certainly didn't think I didn't think they were red robe judges and blue robe judges. That just would not have occurred to me. I might have said, I need to speak the language of Justice Scalia, which is what's the meaning of the Constitution? What was its original meaning? Or I may have to shift and speak the language of Justice Ginsburg, who might have a more flexible interpretation, say, of due process. But it wasn't based on any political party. It wasn't based on the predisposition of any government. In fact, I guess I could say that City of Bernie is really a great illustration of independence. That was a case about the constitutionality of something called the Religious Freedom Restoration Act, which is I think it's a 1993 congressional law, and that just sailed through Congress. I think there may have been 2 negative votes. I mean, think of how astonishing it is to have anything with near unanimity. That was almost 100% unanimous. President Clinton signed it into law, and the U.S. Supreme Court in a 7-2 vote said no. And you could say, well, where do they get that authority? Sometimes people use the phrase counter-majoritarian. That's probably not my preferred phrase because we're always dealing with majoritarian documents. I think of the U.S. Constitution and the 14th Amendment as majoritarian. So the question is not majoritarian or not. The question is which majority document controls. And that was a case where the court decided that the meaning of the 14th Amendment and Section 5 of the 14th Amendment in particular, the enforcement clause, required Congress only to pass remedial legislation, not pass legislation that overruled U.S. Supreme Court decisions. But I think the key thing, I just want to take it back to so many ways to think about independence. And I guess the one area I feel really good about on the court in 19 years is, you know, people might draw assumptions about the reality that someone was nominated by a Republican or Democratic president, but I don't think that's the way judges work. Maybe the trauma of the confirmation process leaves a little residue for a year or two. But boy, once the confirmation process is in your rearview mirror, that's just not how you're thinking. You're thinking, you know, what's the law required? Every judge has their own, you know, kind of instincts in reaction to the fact pattern, which is good. We're sentient beings. You'd like that. And then we just kind of, you know, we pay attention to those, but also pay attention to what the law requires as we try to resolve these judgments. And, you know, I think the proof that there is independence and there are principles out there that are separate from our own worldviews is the reality in the Court of Appeals that, I don't know the most recent statistic, but it's pretty close to 90% of the time we're unanimous on our, you know, so we sit in panels of 3, and it's close to 90% of the time we're unanimous, even though we might have judges, in fact, usually do have judges appointed by different presidents from different political parties. So that's heartwarming to me when it comes to the idea that we're doing something that's independent of politics. But we could go. It's time for Judge Donnelly. She, I'm sure, has some great thoughts about this because it's such an important issue.
Well, I echo everything that Judge Sutton said. I mean, in my experience, serving on a court, where until recently we had our oldest judge was appointed by Lyndon Johnson, and all the way up to judges who were appointed by Donald Trump. And I can tell you that I have never had a sense with any of them, all of the different presidential appointees, I've never had the sense that somebody was serving a cause other than doing their best to apply the law to the facts, which is what judges do. Independent from outside concerns, independent from whatever your personal feelings about a topic or about a group or about an area of law, and that's your job. Now, if you were to listen, as Judge Sutton referenced, if you were to listen to confirmation hearings, mine was not especially contentious, I would say, but and I was with some other judges, but I think on the circuit level and certainly on the Supreme Court, there's the senators who are making the inquiry certainly have a thought that that judges aren't acting independently, which I think is wrong. You might have a sense that the judges are political creatures, but that has not been my experience at all. I think also at the federal level, there's an extra layer of insurance about that, or maybe that's not the right way to put it, but those of us who serve on the federal courts have a lifetime appointment. That means that we don't have to run for election like many judges in states do, and that or be appointed by political officials in the state. Huge amount of huge number of cases are decided at the state level, and I think that's tougher for people who want to run. I mean, there have been instances too that I can think of recently, or fairly recently, where judges' opinions were unpopular, and so there was a successful motion to recall them. One of them was in California, a pretty notorious case, the Stanford rape case. The judge imposed a light sentence. People objected to it and voted to recall him based on his decision. It happened in 2010 in Iowa. I think the Iowa Supreme Court unanimously decided, I think the question was same-sex marriage. There was a motion to recall them or to vote them out of office, and that was also successful. So the danger is always when you are subject to that kind of pressure that a judge might be less likely to take an unpopular stance. But Judge Sutton and I don't have to worry about that, which I think is the way judges ought to be. I don't think you should be concerned about whether you're going to make an unpopular decision and then somebody's not going to like it. Almost every decision that you make, somebody's not going to like for one reason or another. But again, you do your best to focus on the issues and make your best judgment about them.
Yeah, you could describe our job quite depressingly as allocating disappointment to half the people that come in front of us, which if you like making people happy, that isn't always going to work. The other thing about the system, and I guess this is a feature on the federal and state side that helps deal with these problems. Human beings are still human beings, right? So we are all imperfect, and people have good days, bad days, and so forth. But one nice feature of the system is you've got the hardest working group of people in the system, clearly the trial judges. I mean, that's easily the job that's the most demanding in terms of volume, motions, paper. I mean, it's just a very demanding job, and they're alone, which of course probably adds a little efficiency because once they figured it out, they don't have to get the support of somebody else. But one feature of the system that I think helps with keeping us independent and focused on what the right answer is under the law rather than the right answer under someone's worldview or political view is as you go up the ladder, you add numbers, and they can be reassuring. So at the Court of Appeals at the federal level, we have 3 judges deciding each case, and at the U.S. Supreme Court, of course, 9. And to illustrate how that makes us more independent, try this contrast. Imagine if the Wall Street Journal and the New York Times got together and all of their editorials could not be released unless at the Wall Street Journal side, at least one editorial board member from the New York Times approved it. And at the New York Times side, at least one member of the Wall Street Journal editorial board approved it. Or to go to the Legal Academy, if every law journal article had to be co-written by at least one other person with a different worldview, what you get in all those editorials and those law review articles is almost always a little bit of a narrowing of the focus, obviously a more neutral perspective, and they just would read very differently. And I think one thing that's nice about our court systems, and this works the same way at the state and federal level, is by bringing in more participants, it helps to screen out maybe some predispositions people might have. Maybe I, based on my experience, react very strongly to one case, perhaps too strongly. And then I sit down with my 2 colleagues and we start talking about it, and it becomes obvious, maybe after a little while, but it becomes obvious that I'm a little out there on this issue. My views are a little too strong. They're maybe uninformed, or I'm reacting too strongly to the fact pattern. And so I think that helps us with independence. Because to me, independence, it's not just a function, are we acting separately from the elected branches? It's also, are we doing something that's outside of ourselves, so independent of ourselves in a rule of law type approach? Because I don't think people would be very reassured if they knew the judges are independent of the elected branches, but not independent of their own worldviews. That wouldn't make them very happy. They wouldn't think that's what judges are supposed to do. So I think that feature of the system is helpful.
Great. So I want to pull out a couple of threads from what you've both been discussing, especially about the question of how the system protects judicial independence. The decisions that get the most attention often aren't those 90% that are unanimous. Usually the ones that get the most attention are a little bit closer, and certainly they are the ones that are contentious. The most contentious decisions get the most attention in the media and in the public and in politics. Then, as you mentioned, there are sometimes contentious confirmation hearings as well. So you might imagine that some members of the public might see things in a more political light than what you've been describing. Given that, I want to hear a little more about how the system protects judicial independence. You've both been talking about the importance of judges being able to apply the law and doing so from a non-political position. You've mentioned some structural protections for the bench, such as life tenure, the judiciary as a separate branch, and having to build consensus among multiple judges in the appellate system as being important to protecting judicial independence and being an important part of the system. Are there other key aspects of the job or of the system that help maintain judicial independence that people might not think about?
Well, at least at the district court level, one thing that keeps I don't know if it's really judicial independence, but we are working from a whole body of law that's been established by the Supreme Court and by the circuit courts. And there are times where there is no law and you'll be doing trying to apply, but I think every judge is constrained by what judges do, which is working from a body of law, apply that to a particular case. I'm sure there are cases that are popular where people feel that a result has been bad or a result has been good, and I can think of some recent examples where a defendant has been especially notorious, or the case has been in the news a lot, and people express opinions about a decision a court has made. But when you go and actually read the opinion, it's absolutely correct. And so I think just the way that judges are supposed to operate, by applying a fixed set of principles and laws to a certain situation, that's a built-in assurance, unless somebody's going rogue, which we try not to do. So that's one thing, at least that I can think of.
Yeah, I mean, I think, I guess when people think of independence of the federal courts, sad to say for Judge Donnelly and me, they don't think of our courts. They're thinking of the U.S. Supreme Court, and they're thinking of their 50 to 70 decisions, and quite often somewhere between 5 and 10 a year that everybody knows something about. Maybe they don't know the law underlying the issue, but they know the issue because it affects them, right? Rights to abortion, marriage, some of those, really tricky constitutional issues. And I think sometimes the question is, how independent are the courts when it comes to those issues? So I think that gets trickier. But let me start by I said before that criminal issues probably cover half our docket. I'm pretty comfortable with the idea that there's no political correlation with what's going on the criminal side. I don't care. I mean, even the death penalty cases, which often have a little bit of a Republican nominee, Democratic nominee tendency, those are pretty legitimate debates, right? I mean, you've got the conservative group saying it's not in the Constitution, the more liberal group saying sometimes the Constitution evolves over time, and both theories have been with us from the beginning. So that's a pretty legitimate form of disagreement. I think where it gets tricky for the average American is when they see some of these other constitutional debates where they may have strong personal views, and there it's a little harder for them to understand what the court's doing. In other words, it's pretty easy for them to jump to the conclusion, aha, the conservatives won or the liberals won, which starts to make the court look less independent. And I think the key thing there, it gets a little harder for people to appreciate if they haven't been to law school, but the reality is really from the founding of the Republic on, you have courts that sometimes acting in a more formal way with, really careful attention to language and the assumption that language has a fixed meaning. And then you have other cases, sometimes by the same court, sometimes by a different court with other judges, emphasizing a fluid, evolving nature of constitutional meaning. No one side has won that debate. I'd be shocked if in our lifetimes or anyone will win that debate. There's so many precedents supporting each. And I would not, however, jump to the conclusion that proves it's political judging. These are just theories of interpretation. I mean, so Justice Ginsburg and Justice Scalia were famously best friends on the court. I mean, true affection for each other. And they disagree completely about the thing I'm talking about. They just had very different views, and yet really got along, really respected each other's views. I mean, you can go read U.S. versus Virginia, which is the case about the all-male VMI military school, and the 14th Amendment ruling saying it has to be open to women. And you see two justices at the top of their game, very much in disagreement, but these are the same two people with just an awful lot of affection and respect for each other. And what that shows me is not that the VMI decision was remotely political. It was just a disagreement about theories of interpretation. And I think sometimes those constitutional battles put some pressure on we federal judges and the fear that there's politics underlying them. One area where perhaps the American people sometimes are a little more nervous or skeptical of the independence of federal judges is when we get to areas of constitutional law that are a little more open-ended. So, for example, substantive due process doctrine is one that's, I think all judges would agree, is difficult to apply. There's not any real textual hook that tells you exactly which way to go. And, you know, Judge Donnelly and I might have the same views about substantive due process. We might have different views about substantive due process. The one thing I know we would agree about is there are many cases recognizing substantive due process claims. And so I think in an area like that, where there's not a lot of guidance from the Constitution as to what we should do, maybe that's an area where federal judges should maybe be more incremental, a little more cautious, maybe try a little extra hard to find common ground before they announce decisions in that area. But, you know, a way to pull this all together is, let's just say we had the most political of all cases in front of us, a case where the Republican Party sues the Democratic Party or vice versa. The one thing I'm quite confident about the 1,000 federal judges out there is they wouldn't focus on the names of the parties in deciding what to do. They would focus on what laws were invoked in the lawsuit. If it was a constitutional law, they'd go to that provision and the cases under it. If it was a statute, same thing. And, you know, I think the odds are pretty high that they would find a way to resolve that decision that shows the currency was reason, not power. That, you know, they found a reasonable way to look at the law and figure out which political party should win. And if I'm comfortable with those cases, then I think we should be comfortable with most cases in which the federal judges are asked to, you know, decide who wins.
I want to pick up on a few points you both have made and ask, what are the limits to judicial independence? To put this another way, in a caricatured version of judicial independence, one might think and might get the idea that judges and justices can just do whatever they want, which of course is not true. Rather, as Judge Donnelly said, judges are trying to accurately apply the law unless someone is going rogue, which you try not to do. So there are, in fact, various forms of judicial accountability to make sure that no one goes rogue. And I think one might see that accountability as the other side of judicial independence, or perhaps as key to making judicial independence possible. So as you've gone along, you both have mentioned forms of accountability. The most obvious one, of course, is that lower court decisions can be appealed. Judge Sutton, you've also mentioned the need to build consensus among judges deciding appellant cases. Judge Donnelly, you've mentioned that in the state system, judges can be subjected to recalls, though of course that is not the case on the federal level. Are there other ways in which accountability is built into the system to protect judicial independence as well?
Well, I mean, you're accountable, at least as a district judge, and you can get appealed, which, you know, happens sometimes. And so if you've made a mistake, you've got some checks there. I mean, a district judge, a federal judge can be removed for high crimes and misdemeanors, which we try to stay away from. But in terms of, you know, getting called out on a decision you've made, that's really built into the process by the appellate system. You know, I'm just trying to think in my experience if there's, I mean, I've heard stories of, you know, where judges, you know, either they're not deciding cases efficiently or something like that. I guess in the structure of the courts, you know, your colleagues could step in and help you out. But it's a failure of imagination on my part. I'm not thinking of anything right now. I mean, the good news is I can't really think of anybody that needs that. So
right, that might be a very good sign right there.
I mean, I will say that I believe that most people who become judges and come to the federal court are, at least in my experience, are very careful, you know, with the way they make their decisions. I suppose, again, maybe there are exceptions, but it hasn't been my experience. I'm just having a hard time thinking of anyone within my experience that you think might need a little reining in, but I just can't think of anybody. Judge Sutton, you might have seen it more on the appellate level.
Yeah, no, I think I'm a supporter of the system, so I think it works pretty well. And you're right, we both have accountability because both of sets of our decisions can be appealed. That is important. Sometimes people talk about the oath that we're sworn to do justice, rich, poor. So the oath is really telling you, you're going to do this in a neutral way. I'm not sure, I guess for different people that might mean different things. I suspect the thing that maybe I found most humbling and in a way its own accountability measure was not as much the risk of appeal or the oath. What's very humbling about the job is after you've been at it a few years, you suddenly realize that things that looked easy at one point, you suddenly get the same issue through a slightly different lens. And when you looked at it the first time, it just seemed so easy. And maybe in my case, I wrote an opinion that maybe overwrote it a little bit because it looked just so easy. I was trying to do my job. I thought this was right. And then along comes the same issue from a slightly different angle. I'm like, oops, I hadn't thought about that. So that's its own internal accountability point that, we don't like. This applies to all judges, trial or appellate. You don't like to be reversing the call the next case, right? That's not consistent. We weren't really, and that's something only we can measure. I guess that's really a conscience point, but I think it's the rare judge that doesn't appreciate after a few years that it's you have to be confident about the job, but you're going to be overwhelmed by humility eventually because you realize how complex things can be. And I think that's helpful because that usually means I don't overwrite the next time, so maybe after 5 years in the job, I was realizing probably a good idea to cabin this case in this little area because, I might not appreciate that it could look a lot different in a different setting. So that seems to me a form of accountability and pretty helpful, but I would call it quite internal rather than external.
Well, since you've started reflecting on what you've learned over your career, I would like to ask both of you to reflect on whether the idea of judicial independence or perhaps the public perception of it has changed over the course of your career. Some of the cases that we are discussing in this series are about structural questions related to judicial independence. For example, cases about the relative powers of Congress and the courts or Congress and the president, where the court was called upon to consider a question that hadn't been answered before. Perhaps there are some instances like that, some cases that come to mind during your career or historically that you see as important moments in defining judicial independence. Could you talk about one of those or more broadly reflect on how you think these questions have changed over the course of your career or over the past few decades if you'd like to look a little further back?
Yeah, I'll go back to the case of City of Bernie because that's such a great illustration of an area where you can have a very popular law, the Religious Freedom Restoration Act. Quite a few states passed similar laws proving their popularity. And yet the public accepted that ruling. The public was not happy with the underlying Smith decision, Smith versus Oregon. That's what led to RFRA. But after City of Bernie, I didn't see calls for impeaching justices or changing the court or adding justices or taking away justices. It was a case where I think, there was obviously disagreement. A lot of people really liked that law, so they weren't happy with the decision. But that struck me as a pretty good illustration that the American people see this role of the court that was not a political point. If you think of the politics of RFRA, it was whether you favor religion or not. There was no favor religion or don't favor religion block at the court. It didn't translate to political parties. It was a 7-2 vote. So it seemed like a very apolitical decision about a very political law. So that to me, that's the very promising, optimistic view of the continued independence of the courts. I think, speaking for myself, but I suspect Judge Donnelly shares some of these views. The last 3 to 4 decades have put a lot of pressure on the courts, and it's hard to know where to look. If there's one place to blame for that, but it does seem the confirmation process for U.S. Supreme Court justices and increasingly Court of Appeals judges is not great, because the thing that I think is most distressing about it is increasingly the votes for justices and even Court of Appeals judges in the U.S. Senate tend to be quite partisan. And the worry one has is if the American people see their elected senators voting on partisan line for U.S. Supreme Court justices, it's not a big leap to think, they must be political actors. Why are they voting along partisan lines? And the question is, how do we handle that? I think part of that is an issue for the U.S. Senate, but I think part of this is an issue for the American people. And the question for me is it possible maybe we're asking a little too much of the court? If you ask the court to resolve some of the trickiest issues in society as opposed to the democratic branches, you can't be surprised if the American people are going to have a really strong conviction about who should be on the court. And that's not binary. Like, you can't just say it's this case or that case. It's just something that's happened over quite a few decades, and it took us a while to get to this point. I think it's going to take us a while to get out of it. The good news is I feel like the U.S. Supreme Court, all 9 justices, are very aware of this problem. They do not want to contribute to it. At the same time, they want to do their jobs. I think the same is true of the rest of the federal courts. It's a tricky dynamic. We judges care deeply. I mean, it's existential for us what we think the right views of interpretation are, the right view of the role of the judge in American society is, particularly the federal courts. And that one is along a very big spectrum with an awful lot of data points. And so I just think maybe it'd be nice if the American people didn't expect federal judges to resolve all the key disputes, at least not initially. Like, let's try to resolve some of this locally and be reasonable about it. And that probably would be good for the federal and state courts in the long run. And I think we federal judges, when we can, should really work hard to find common ground, because very hard to say that a 7-2 or a 9-0 decision or even a 3-0 decision is political, particularly when it has judges nominated by both parties. So this is a very tricky issue. I think I would call it a somewhat fraught time in the history of the federal courts, but I'm still pretty optimistic, and I think City of Bernie is a great illustration of a politically charged case that people accept. They might not agree with it, but they accept it as an apolitical decision.
I agree with everything Judge Sutton said. I will also say just the way, really the explosion of different forms of media, different ways of communicating have enabled people to express their feelings, regardless of whether those feelings are well informed, in a variety of ways. And so, depending, if you're going to watch a television show or listen to someone give a speech, they may speak very passionately about something, and it could be completely wrong. And judges really aren't in a position to respond to that. I will say, at least in my experience, I would say 98%, 99% of the work that a district judge does is utterly apolitical. It is resolving disputes among parties about all kinds of things, none of which have anything to do with have any constitutional dimension. But in the time, the few times that we are called upon to make those decisions, what's new to me anyway is the personal threat that judges can be under because of a decision that you have made that someone or group doesn't care for. People are able to find, your home address, your telephone number, and foment all kinds of discussion about what should happen to a judge and his or her family based on a decision the judge has made. And that can happen by the way, when a case is utterly apolitical, just a disgruntled litigant, and far too often, frequently, judges have paid that price. But that is as Judge Sutton said, the pressure that is placed on the federal courts in that way is much more intense than it was before. And I don't know that we'll ever be able to undo some of that. I mean, people get kind of siloed into their ways of getting information, and it's sort of hard to break that. I mean, on either side, depending on what your views are, you can seek out a place that will confirm whatever your feelings are, and then you never have to hear anything else. So you could, you could think federal judges are, running roughshod over everybody's rights. Maybe if you actually read the judge's opinion, a radical idea, you would learn that there was something, it wasn't what you thought at all. I don't really know how to put that genie back in the bottle, quite frankly. I'd like to think it could be done, but it's very worrisome.
So Judge Sutton mentioned the City of Bernie case. Is there a particular case for you, Judge Donnelly, that highlights some of the things we've been talking about, whether as a particularly good example of independence or a case where judicial independence was challenged?
Well, I think all we have to do is look at within the last few months, the conversation about the results of the election. You had judges from all sides, I think largely appointed by the last president, who roundly rejected the arguments that were made, and that's not political. It was based on their examination of the facts and applying the law. So I mean, I guess I'm biased because I'm part of the federal court, but I think the federal court does a pretty wonderful job of not becoming political. I mean, we're humans, I guess, but I think that's a pretty recent and pretty powerful example. I think the federal courts have had to do a lot of work in the last few decades. I agree with Judge Sutton about that. Maybe work that others should be doing. Not the federal court is maybe not the place to go to fix everything.
So you've both really nicely led into the last question that I wanted to ask you as we come to a close of our discussion. What might be one or two things that you think are the most important things for the public to understand about this topic? Again, we are looking towards a public audience, in particular towards teachers and ultimately towards students, so towards young people. Is there a way that you would like them to be thinking about their own role in protecting judicial independence, or ways that they might think about the system and its importance? You've mentioned already that perhaps there are some questions that should go to the political branches rather than to the courts to decide. Are there other takeaways that you would like to leave us with?
Yeah, so it's I really wish I could go back and teach 7th grade civics. Having been a 7th grade geography teacher, I feel like I know the audience, and some of this is not easy to teach. Some of it's quite technical, but I think there are a few things I might emphasize. I think a really big question to just constantly be putting on the table is, who decides this? Is this for a jury system? Is this for a trial judge? Is this for the legislature, the governor, the president, or for the U.S. Supreme Court or the federal courts in general? So I sometimes think we focus much more on, did the Yankees win? Did our team win versus is this actually a baseball game? Or, sometimes I just think that would help a little bit. I think there's also this danger of a single story, and I hate to do this with the Federal Judicial Center, but since the ABA is involved, maybe they will agree with the point. We're not the only game in town. And I do think if there's an area of civic education that I think could be improved, it's reminding people that most cases actually are not in the federal court. The last year for which we have numbers, if you focus on criminal cases, I think it was 17 million criminal cases for the year in the state courts and 70,000 in the federal courts. I think the number for all cases was 84 million in the state courts, 400,000 in the federal courts. So if you care, as Judge Donnelly and I both do, about the rule of law, fairness, equality, dignity of human beings, if it's not happening in the state courts, it ain't going to be fixed in the federal courts. So we want to remember that there are two sets of systems here. They both have really important roles. And I guess my last thing is, no country in world history has embraced constitutionalism, judicial review the way we Americans have. And for me, it's a crown jewel. So I'm not denying that. I'm all for judicial review. I think it's served this country so well. Think of Jim Crow. But I do think there's a little bit of a danger of it all being legalized and all law-driven. Nothing lasts just because it's in a court decision. I mean, the only thing that lasts are the values of the people. And so if you really care about something, I would not say the courts are the first place to go. The first place to go are persuade the people in your community, persuade your city council, your legislature. That's where movements really get traction, and that's where victories are just really lasting because they become part of who we Americans are. And in a way to illustrate the point, a law and a case that most teachers would teach would be compare Brown versus Board of Education, arguably the greatest U.S. Supreme Court decision, with the 1964 Civil Rights Act. And, obviously both great, so we're comparing two great events. But if I could only have one, I was forced to one or the other. For me, it's a very obvious choice that I would want the 1964 Civil Rights Act. And the reason is, how do we see ourselves? Are we a country where 5 to 9 justices decide our key values? Or are we a country that develops a social and political culture where the majority thinks it's a good idea to look out for the rights of dissenting voices, minority groups, different faiths? And what's so brilliant and wonderful about the 1964 Civil Rights Act is it's a majority law designed to protect dissenting voices and minority groups. And that's as good as it gets, in my view, when the people want to do that, as opposed to the court needing to do it. It's always a failure when we judges have to do it. So I'd prefer fewer of those failures and more 1964 Civil Rights Acts.
I would say that if I were going to give somebody advice, a student or really anybody who's seeking to find out more information about an issue, rather than listening to what somebody else says about a case, rather than listening to somebody criticize the case as a judge making his or her own law, go read the opinion, read what it says, and then take a look at the law that the judge is citing. Take a look at some of the other cases. You should really educate yourself. It's easy to pick up something you've read on Twitter or heard somebody say on television. But if you really want to know what happened, go read the case. And I think you will be surprised in most cases that what someone represented to you that case meant, that it doesn't mean that at all. And that it's based on long-standing principles of statutory interpretation, or it's applying legal precedent. It's going to take a little more work than just adopting someone else's view, but then you'll really have checked yourself, and you will have informed yourself. I think that if we did that in life, try to find out what really happened, we'd have much less strife amongst our citizens if we really took the time to educate ourselves about a topic, and about when you're talking about a judge's decision, read the decision. So that's one thing that I would say that I think will really help you understand how judges make decisions and why they do it.
Wonderful. Well, thank you both for all of your comments, but especially for those inspiring words at the end. And if I may make a brief plug for following from Judge Donnelly here, our next session will be talking about how to read primary sources, including some decisions related to the cases that we're talking about in this series. So if you'd like a little help on how to do that, I'll be joined by another historian from the FJC in our next session for that discussion. So thank you both for this, and we appreciate all of your time and your comments.
Thank you so much. It was a pleasure.
Thank you.